And good afternoon, everyone. So I am Carrie Danko, the 2021 president of FAAR, and I'm excited about what we're going to be talking about today. So I know that many of us have read in the news about legal challenges brought against NAR, real estate firms, and MLSs, and see these cases as direct attacks on the value that we provide to our customers and clients. Over 90% of homes searches start online, and that information didn't just appear out of thin air. It is aggregated in a usable form because we utilize the very mechanism that these lawsuits take aim at, our multiple listing service. But I also know that the vast majority of us don't take great pleasure in sifting through lawsuits or reading Department of Justice statements. So that's why I'm excited about today's speaker, Leslie Muko, who is the Deputy General Counsel at the National Association of REALTORS. Leslie is going to share with us what came out of the recent DOJ settlement and what it means for us as practitioners. I know this can be confusing, so please ask any questions that you may have today. No questions are bad questions, and chances are that other people on this call are having the same thoughts as you are. So just pop your questions into the chat or unmute yourself and just ask away. So before I hand the floor over to Leslie, I want to recognize our generous sponsor, Topside Federal Credit Union. And we have Lauren Bruning here with us today. And as you know, we could not do all the things that we do at the association without, and bring the value that we have without all these incredible partners like Lauren and Topside. So Lauren, thank you for being here. Welcome. And please tell us a little bit about what's going on at Topside.
Thank you so much. As members of FAAR, you guys are all eligible for membership with Topside Federal Credit Union. So I just wanted to share with you a little bit of the excitement of what that means. We're member-owned, not-for-profit. That's the unique difference of a credit union, is that we're truly here to support our members. And so some of those things look like having youth saves accounts for your kids or grandkids that earn 5% on the first 500 until the child's 20th birthday. They get things like a matching quarter saver. Once it's full of $10 worth of quarters, we actually give them another $10 to say, great job for learning how to save. That means at 9 years old, getting the opportunity to have a checking account, which might seem scary, but in today's society with coin shortages and credit cards everywhere, it's great to learn about how to use a debit card while they're still at home, still listening. And we have a My Card Rules app that you can turn off that card, turn it on, add spending limits, even get notifications right to your phone that let you know as soon as it's been swiped. I actually use that one on my personal card because if anyone else gets my number, I want to know before it even hits my account that it's been touched so I can turn off that card. That also means for our teenagers, when they turn 16 and 17 and they get their first direct deposit job, that they're going to get a bonus of $25 to congratulate them on that. In addition, if any of you are military, active, dependent, retired, we want to say thank you for your service and offer 8% on the first 500 for life with our military saves account. And if any of you have currently purchased a car or are thinking about it, we are offering a 90-day no pay right now on auto loans. And for the future going on, we're going to be offering 1% cash back up to $250. So if you want to get a little cash back as well as our great rates, that's a great thing to take advantage of. You can apply for all of those on our website. I also want to share with you, you may not know that in the past year, we've brought on a fantastic business lender. Her name is Kathy Roscoe, and she can help you with any residential investments, commercial investments, and equipment loans as well. Our online banking and mobile app are just as exciting as all of the competitors. You can take pictures of your checks, put them right in your account, as well as pay a person even if they aren't part of the credit union. Kind of like Venmo or Cash App, we have that accessibility straight from your account, so you don't have to worry about the third party. We have a lot of really great resources on our online website. If I didn't have to come into the credit union to work, I'd never come to the building because I can do everything right on my phone. We have 2 locations though in Fredericksburg, if you do like that in-person feel. In Massaponax, across from the new Publix, as well as in downtown Fredericksburg, across or right next to the Almonds Barbecue, so you can get a nice treat after your banking needs. We also have 2 locations in King George as well, one on base where we started, and then one right on 301. You can actually take advantage of any of these things on our website as well. It only costs $1 to join the credit union and to open any accounts. I will drop our website and my contact information in the chat. If you have any questions or need any help, I'm happy to assist. Thank you so much.
Thank you so much, Lauren. And so now I am going to turn it over to Leslie, and thank you so much for being here with us today.
Hi, good morning, everyone. I'm very excited to be here. I appreciate the invitation to talk about what's happening with NAR Legal, which there's plenty happening. I'm going to share my screen here. Make sure I do that correctly before I get going. Yeah, okay, cool. Also, I should mention that Fredericksburg has a special place in my heart. My parents lived in Fredericksburg for well over 10 years, so I'm very familiar with your beautiful area and just really happy to be here with you today. There's a lot to cover. We kind of were set up for what we're going to talk about today, which I'm going to cover the NAR DOJ settlement that you all recently heard about. And I'm also going to talk about some other NAR litigation that's happening related to the MLS, the payment of commissions. There's plenty of activity there. And then finally, I'm going to end with a discussion about the recent Code of Ethics Statement of Practice 10-5 adoption that happened just this past November. So we will get started with the NAR DOJ settlement. And if I look like I'm not looking at you, it's because I have a couple of screens and need to make sure I'm keeping pace with the slides. But so as you likely know, in mid-November, NAR and the Department of Justice reached a settlement related to questions that the DOJ raised about the MLS and commissions. So this settlement resolves all of those questions that the DOJ raised, and it also requires that NAR adopt certain rule changes. So the rule changes, I'm going to go into more detail in a few minutes, but they all come as a result of the settlement and really seek to more explicitly state what's already in the spirit and intent of NAR's Code of Ethics and MLS policies. There's a few things I want to highlight before I go over the rule changes, and that is that there is no immediate action for you to take right now. At this point, we are working with the DOJ to craft these proposed rules. So nothing changes right now. All you know and need to know is that there is a settlement, and I'm going to give you an overview of what those proposed changes might look like, but there's been no change right now. There will definitely be more advertisement communication about those proposed changes as we get closer to actually seeing what those proposed changes are and when they will be implemented. There's a number of things that have to happen before that will even take place. First, the court has to approve the terms of the settlement, which it will do by entering its final judgment. The court has not entered its final judgment yet. And then also the proposed rule changes require the DOJ's approval, as well as NAR's Board of Directors approval. So at this point where we are with the settlement is we have provided our draft proposed rule changes to the Department of Justice. And we're waiting to hear back from them about our proposed rule changes, and we will continue to engage with them until we do reach an agreement on what they look like. At that point, they will be presented to the NAR Board of Directors. We are hoping and anticipating that will happen sometime this spring, but that's just a guess until we do reach that approval and agreement with the Department of Justice. NAR, a few things I want to point out about the settlement itself is that NAR, as part of that settlement, is not agreeing or admitting to any liability, wrongdoing, or truth of any of the allegations that the Department of Justice makes in the action. And importantly, NAR is not required to pay any fines or payments as a result of the settlement. And that's really important because that this settlement allows NAR to avoid protracted litigation that is timely, time consuming, it's expensive, And it allows us to focus on our core mission, which is, of course, helping you as members serve consumers and advance the dream of homeownership. So let's talk about what we all really want to talk about, and those are the rule changes. So in a nutshell, there are 4 rule changes, and I'm going to quickly just go over, and then I'll go into more detail about each of them. The first rule change is that the offer of compensation must be disclosed, and there will be an affirmative obligation for MLSs to include this field in all publicly facing displays. So if an MLS has a publicly facing website or in consumer listing sheets, the offer of compensation must be disclosed. There will also be an obligation that makes sure that clients know what that offer of compensation is on any particular property before an offer is made on that listing. The second rule change is that real estate transaction services must not be advertised as free. The third rule change relates to filtering of MLS listings to consumers, and there will be a prohibition on filtering those listings to consumers in a way that filters based on the commission amount or the listing broker or agent's name. And then last, the fourth rule change is that lockbox access must be available to all real estate licensees licensed in the area where the property is located. And as we'll discuss, there can be reasonable conditions on the delivery of that lockbox access. So starting with the offer of compensation. Offer of compensation must be provided to consumers. So here we're proposing and envision that there will be a new MLS policy statement, and that policy statement will accomplish a few things. First, it will prohibit MLSs from restricting or discouraging participants and subscribers from publishing or displaying the offer of compensation. So as I said just a few minutes ago, that means that the offer of compensation must be displayed on any publicly facing website that the MLS has, and also on those MLS listing sheets that are provided to consumers. It will allow MLSs to require that a disclaimer accompany that display of the offer of compensation to make clear that that offer is being made only to other participants of the MLS. And then finally, it will require that realtors make sure that their clients know what the offer of compensation is on any particular listing before an offer is made on that listing. So in addition to that new MLS policy statement, the IDX and VAL policies will also have to be amended to explicitly state that the offer of compensation can no longer be designated as confidential. Remember that now must be provided to consumers and published by the MLS. The next rule statement or rule change has to do with the advertising of services as free. And as you all likely know, this is already actually prohibited in the Code of Ethics Standard of Practice 12-1, but the Department of Justice wanted further clarity on this. So we are recommending that the Code of Ethics revision be made to Standard of Practice 12-1 that expressly and clearly prohibits members from advertising their services as free or available at no cost to clients, and that a new MLS policy statement be adopted that mirrors that prohibition. And so here it's really important that you note the use of the term client because our intention is to allow realtors to continue their prospecting services, like offering free CMAs to prospective clients. And we anticipate and intend for this prohibition on the advertising of real estate transaction services as free only to apply to clients in the context of a particular real estate transaction. The next third rule change has to do with the filtering of listings. And here it's important and notable to recall a realtor's ethical duty under Article 1 to act in their client's best interest. So as you all already know, this ethical duty requires that you act in your client's best interest, which would require that all properties that fall within a client's stated desires or parameters for their search be provided and delivered to that client, regardless of offer of compensation on the listing or the name of the broker or agent on the listing. So this rule change will just affirm that duty and will restrict members from filtering listings based on that offer of compensation or the name of the listing broker or agent, which under our existing duties should already have been not happening currently. Here again, the IDX and VAL policies will also need to be amended because they expressly allow for filtering based on the offer of compensation level of service and realtor membership. And you might note that that level of service and realtor membership were not called out in the specific rule change, but those last two ways of filtering MLS listings could be used as a way to kind of circumvent the restriction on filtering based on offer of compensation or level of service. Here, we don't anticipate, and we do understand that there is some business need and use of filtering based on some of these fields behind the scenes. But the intent here and the hope is that the proposed rule change will just relate to the delivery of listings to consumers and not prohibit the legitimate business use of some of these filtering categories behind the scenes. And then finally, what has been really the most, I say, controversial or talked about a rule change relates to lockbox access. And so here, with the seller's permission, all active real estate licensees must be eligible for lockbox access. So again, I'm going to start this conversation with recalling an existing ethical duty under Article 3 of the Code of Ethics, and that is a realtor's duty to cooperate. So this is another longstanding duty that I'm sure we are all familiar with that requires realtors to cooperate with other brokers. And that would include, sharing information about a listing or making a listing or property available to another broker, regardless of that broker's membership status when it's in the client's best interest. So currently, MLS policy permits lockbox providers to determine locally whether or not temporary access codes can be available. So this rule change will change that and require that local discretion be removed and that all lockbox providers permit the use of temporary codes to accommodate access by non-participants of the MLS. The good news here is that Supra and CentralLock already have this capability to issue temporary codes. So that does allow for this to actually already be happening and to happen once this rule change takes effect. So here, as I said, it is the rule change will allow all active real estate licensees in the geographic location where the property is listed to have lockbox access. But as I said, there can be reasonable restrictions on the delivery of that lockbox access. So for example, they can be required to provide sufficient information or evidence of their licensure, that they are, in fact, a real estate licensee in the area able to show property. They can also be required to execute a lockbox agreement just as any other participant is required. And if there are any safety precautions or other background checks that are conducted on another applicant, those same types of background checks or restrictions or safety protocols an MLS or lockbox provider might enter into with prospective key holders can apply to these non-member real estate licensees. And then finally, the association or MLS can charge the non-member a reasonable amount for the lockbox access, which you'll want to determine locally with consultation with counsel, but really it should never exceed the amount charged to other participants and subscribers. So those are the rule changes that will take effect at some point in the near term. Again, I just want to highlight that there is no immediate action required and that these are just the proposed rule changes. And I've kind of highlighted for you what we're envisioning these proposed rule changes will look like. But of course, they're not final until they're final and presented to the board of directors for approval, which, as I said, we anticipate will be sometime this spring. But it really just depends on the timing of hearing back from the Department of Justice on their agreement to the proposed rule changes. And then we will implement the final rules, but there will be plenty of communication surrounding what these new proposed rules look like, how they will be implemented and when they will be implemented. And to that end, you can go, I want to share a couple of resources about this. And so the first resource I want to share is actually moving back to Article 3, the duty to cooperate, which I mentioned in the lockbox access rule change. So we have a new resource here, just totally dedicated to Article 3, a reminder and explanation of what this Article 3 duty to cooperate entails. And then I encourage you to visit NAR's dedicated landing page about the NAR DOJ settlement on nar.realtor. There you'll see the initial video from President Charlie Oppler announcing the settlement back in November. You'll also see a video from me with an update very similar to what you just learned here about the proposed rule changes. And there's a list of FAQs that are growing based on the questions that we're receiving about these rule changes from members. So I encourage you to go to this page. You can link to it actually right from the homepage. It's linked right there on the homepage. And in my materials here, you can also see the link. But we will continuously be adding more information to this page to keep members updated about what's happening with these rule changes and the settlement generally. I do also just want to highlight that in working through these proposed rule changes, we have received lots and lots of questions, comments, insights, concerns, suggestions from members. And that has all been really helpful as we've worked to finalize rules that do serve our members and consumers best. So I encourage you to continue to share that feedback with me, with my colleagues, with NAR, so that we can make sure that those final rules work best for consumers and members.
Would this be a good time to ask a couple questions?
Sure.
Okay, so I had a question in the chat asking, will the amount of compensation being paid to the listing company also be required to be public, not just the buyer side?
No, it'll just be the offer of compensation to the buyer broker.
Okay, Janet, if you have any follow-up questions, please just unmute or put it in the chat. And then I got an email from an agent asking a question related to the thought that there might be some erosion of buyer access if we're going down a road where there might be some shifting eventually of those closing costs and compensation being shifted to the buyer and get to a point where they might actually be paying their own buyer commission. Has there been any thought or discussion about how buyers could finance that? I know that's sometimes a big hurdle for folks, is to have to bring even more to the closing table.
Yeah, well, I mean, that sort of highlights one of the great things and the way that the MLS works for the benefit of buyers and sellers. Not only does the MLS obviously provide the most comprehensive property information, but it also facilitates this payment of commission. And as a result of that, buyers oftentimes are not paying their own commissions. Now, we have always encouraged that members use buyer representative agreements that clearly spell out how the buyer representative will be paid. But right now, those buyer commissions, that if they were paid directly by the buyer, banks are not financing them. So that is one of the benefits of the existing MLS. And as we go through some of this other antitrust litigation, you will see that there are plaintiffs, class action law firms to be exact, challenging the notion that buyers don't pay their own commission. So we can go through that in a little bit. But I mean, I guess that just remains to be seen. It's always an option, right, for the buyer to pay the commission. Is that in the buyer's best interest? Does it make home ownership more difficult, more expensive, because the buyer has to come up with that down payment to begin with, and now we're talking about more money on top of that. So that's why the MLS and the way the system is right now works for both the seller and buyers.
Okay, before we move on, are there any other questions? I don't want to stifle y'all's curiosity, so please either pop it in the chat or feel free to unmute yourself if you want to ask something.
I was just going to add, I remember well when buyer representation was first implemented and sellers said, fine, if you want your own representation, you pay for it, buyers. That lasted all of 2 seconds because they all have other commitments to get their loans and stuff like that. So I feel like deja vu a little bit here.
Yeah, it always comes full circle.
Yeah.
All right, thank you.
Yeah, and if other questions come up as I go along about the DOJ settlement or anything related to it, obviously I can take them at the next opportunity. But when it rains, it pours. There are other lawsuits out there that you likely have heard about, and so I just want to, kind of go over what those are and what the allegations are and where we are in those cases. So, at a very basic level, these antitrust class action lawsuits, of which there are now 4, losing track, 4 antitrust class action lawsuits. At a very basic level, all of these cases are challenging the MLS system and the way commissions are paid. And we have them being challenged from home sellers and now home buyers. I don't need to tell all of you that the MLS system creates a competitive, efficient, and transparent real estate market that does benefit both buyers and sellers, as well as members of the MLS, and that it fosters communication between brokers and then provides buyers and sellers with the greatest and best number of options. The plaintiffs' attorneys in these cases misunderstand and mischaracterize the MLS, its pro-competitive and pro-consumer aspects and attributes, which the MLS was designed with home sellers and home buyers in mind. So on to the litigation. Here are two of the class action lawsuits. In 2019, 9 class action law firms filed 2 lawsuits, Merle in Illinois and Sitzer in Missouri. There was a third one, Sawville, that got consolidated with Merle in Illinois. And it's not uncommon when there are these class action lawsuits that copycat class action lawsuits are then filed. And that's exactly what these are, because they contain virtually the same allegations, with the exception of the Missouri case containing some state law claims. But they were filed against NAR and the same 4 corporate defendants: Remax, Realogy, Keller Williams, and Berkshire Hathaway Home Services. And the main allegation in these 2 lawsuits are that sellers pay too much commission. So the class action lawyers here in these cases are arguing that NAR's MLS rule that requires MLS participants to offer compensation to cooperating brokers that represent the buyer leads to an artificially inflated and thus anti-competitive commission being paid by sellers. So they argue that the commissions for buyer representatives would be lower, but for NAR's MLS rule, because buyers then don't have a say in the negotiation of those commissions, because they're between the listing broker and the buyer broker, and really the seller and the listing broker. And the class action attorneys argue that the commissions would be lower if the buyers had a say in these negotiations. They also say that they would be lower and should be lower because of the buyer representative's diminished role in the transaction due to the widely available information on the internet, which is because of the MLS, thank you. But they challenge the value of buyer brokers. They really say, there's so much information, buyers are doing their own research, they're finding their own properties on the internet, and they really have a diminished role in this current market. And why haven't the commissions for buyer representatives come down? They point to NAR's MLS rules and that requirement of the offer of compensation as the reason, among other things, that buyer agent commission has not diminished. They also allege the Code of Ethics misleads consumers because it allows realtors to advertise services as free, which you all know is not the case. There's a specific standard of practice that outlines the conditions under which you can advertise your services as free, which is not to mislead consumers. That prohibition will be made more clear. As I mentioned, in the Department of Justice settlement, we will be making that just a very clear prohibition on advertising services as free. And the plaintiff's attorneys argue that the code effectively discourages the negotiation of commission, which we all know is negotiable and always is negotiable. And they also allege that the commission should be lower because in other countries, real estate commissions are supposedly lower where they don't have an MLS. So these first 2 lawsuits, as I said, they purport to represent a class of sellers who within the last 5 years have used one of the named 24, identified 24 association-owned MLSs. So these MLSs are not parties to the lawsuit. They are not defendants. They were named in the allegations. And so this class of purported plaintiffs would consist of sellers who sold their home using one of those association-owned MLSs in the last 5 years. NAR filed motions to dismiss in both of these lawsuits. They were denied. So the cases are ongoing. We are in the next stage of litigation, which is discovery. And next up will be class certification. And so the motion to dismiss was an opportunity for NAR to win. The class certification is another opportunity to win, because if the plaintiffs are not able to certify a class, which will be difficult for them to do because They have to prove typicality, among other things, among the purported class of plaintiffs, which will be very difficult to do given the uniqueness and variability in each real estate transaction. So this is another opportunity where NAR could win, because if the plaintiffs are not able to certify a class, these cases instantly lose appeal to the class action attorneys, who are really hoping for that big monetary win at the end, because they take these cases typically on contingency. So these classes involve home sellers, and up until relatively recently, these were the big cases, which was plenty. But we saw a new trend of class action lawsuits, and these cases involve a purported class of home buyers. And these are the Leader and Conti cases. So earlier this year, 2021, January, a couple more lawsuits and class action firms joined this fray and filed these cases on behalf of buyers nationwide. And the first case is Leader, that was filed in Illinois, and it's called Leader because of the named plaintiff. And the allegations in both of these complaints are very similar to the Merle and Sitzer cases. They reference many of the same rules, but here again, they are purporting to represent a class of home buyers who they now allege are damaged by NAR's MLS rules. The claim here is that buyers are damaged because the commission sellers pay is passed off in the purchase price of the home, and thus buyers allegedly pay more for a home than it is actually worth. So a second Conti case, that's a copycat case. So as I said, with Merle and Sitzer, it's not uncommon to see these copycat cases. We saw that happen with the home seller cases. Now we're seeing it with the home buyer cases. So there was actually just last week that Conti case was filed in California. And this one named, so the Leader case named all of the same defendants, NAR, those 4 corporate defendants. The Conti case named NAR, the same 4 corporate defendants, but also added a few new defendants, San Francisco Association of Realtors, the San Diego Association of Realtors, Compass, Sotheby's, and Rodeo Realty. So before I move on to the Code of Ethics, there's one more lawsuit I want to highlight, and I don't know if anyone's heard of this one either, but it was filed recently against NAR by Rex Brokerage. And they sued NAR and Zillow, alleging NAR's MLS rules and Zillow's adherence to those rules as a member of NAR's anti-competitive. And this case really focuses on NAR's discretionary anti-commingling policy, which is, and I say discretionary because it's not a mandatory policy, but up to the local discretion as to whether or not the MLS adopts it. And that commingling, non-commingling rule requires that MLS listings be displayed separately from other listings. So on Zillow's website, when it became a member and a member of these MLSs, Zillow created 2 tabs for listings. There's one tab that says agents listings, and they create a second tab that says other listings. And Rex's listings, because they are not a member of an MLS, they were moved into this other listings section. And Rex's allegations in this case is that moving its listings to the other listings tab deprives consumers of property information and misleads consumers to believe that their listings are not represented by a licensed real estate broker. And Rex argues in this case that sites like Zillow are critical for providing consumers with accurate and comprehensive information. Rex fails to recognize that display would not be possible but for the existence of the broker cooperative in the MLS. And as you all know, and as we've kind of talked about here or touched on throughout all of these cases, the MLS has been repeatedly recognized as pro-consumer and pro-competitive. And Rex is really trying to undermine that value for its own benefit and take advantage of something that it has not contributed to. We believe, of course, that all of these lawsuits have no legal basis. We are vigorously defending them, and we will continue to promote the benefits and pro-competitive, efficient, and transparent aspects of the MLS. And so I tell you all this, and you're probably like, well, what do I do now? How can I help? What do I need to do? What don't I do? And the answer is that there's a lot that you can do to help with these lawsuits. We are encouraging members to be out there talking about your value, talking about the MLS, helping consumers understand the value of the MLS and how it works, both for the seller's benefit and the buyer's benefit. Talk about how you're compensated, really educate consumers about your value, the MLS, and compensation. The broker cooperative MLS system is designed to incentivize that cooperation between brokers who share their information all in one place. That's for the benefit of home buyers and sellers, so that home buyers have all of the most comprehensive and accurate available information about available properties, and then sellers get access to a large pool of buyers because of the MLS's effort. And then sellers can get that best offer in the quickest amount of time as possible. So please be talking to your clients, to consumers, about your value. Help dispel the class action plaintiff attorneys' notion that buyer representatives have a diminished role in the transaction because of the internet. I mean, we all know that there's much more the buyer representatives do. The services are much more than just locating a property on the website. So just help promote the message about realtor value and how you're getting paid, through the MLS and how it benefits consumers. And to that end, NAR has a number of resources to help you have those conversations. We have these member message talking points about the antitrust lawsuits to talk about exactly what I've said, that you're champions of home ownership, property rights, the communities you serve. I mean, that's, I think, something that really distinguishes realtors, is how active and involved in your community you are for the benefit of your community. That the MLS system exists, and it's pro-consumer, it's transparent, it's efficient, and it's creating these marketplaces for the benefit of home buyers and sellers, and that you are the local expert in all of the services that you're providing to help buyers and sellers close that transaction that serves both of their interests. A couple of other resources that we have developed to help you that can be very easily incorporated into a listing presentation or when you talk to consumers are this microeconomics of buying a home. And this goes to the question that was asked just a little while ago about buyers having to pay that commission and what that would mean. And here's the MLS in action, what it does for consumers, sellers, and buyers. And then I guess I have a choice. So anyway, I encourage you to find those on NAR's website, use them, talk to consumers, and just educate consumers. We are definitely trying to do that from NAR, but there's 1.4 million of you, so there's a lot of good that you can do in spreading the message with us. So I will stop there. If there are any questions specifically about those lawsuits, or
I think we're going to have some. I see that Chip unmuted. Chip, you want to go ahead?
Yeah. Well, Leslie, I appreciate what you're saying, and I think most realtors show their value to their consumers all the time, but that's not where this is coming from. This is coming from competing ideas of how real estate should be done, and a few consumers that are taking opportunistic consumers here. In general, our clients are very happy, and I don't know why we need to stir them up about this lawsuit per se. That's my 2 cents.
No, absolutely.
This is coming from a bigger place.
Yeah, I want to be clear. We're not suggesting that you tell them about these lawsuits, just to educate them, because I don't think consumers understand about the MLS and its existence and why it exists and how it exists for their benefit. And there is confusion in the marketplace about how real estate professionals are paid, whether that's on the seller or buyer side. So that's the message that's going to help us in these lawsuits. And so we ask that, to the extent you're able to help further that message. But I agree, it's class action attorneys are motivated.
That's just not what's driving this. That's all. So.
Yeah, I would have to agree with Chip that this is a money grab, plain and simple. And I find it ironic that lawyers who obviously, I'm going to say, make too much money, have the gall to come after us.
Yeah,
I just think that's the height of hubris, and it's quite ironic.
I mean, we feel the same way. The real estate industry is always under scrutiny, whether it's from, private plaintiffs or the government. It's a foundation of our economy, and it impacts like every single American. We either buy or sell a home at some point in our life. And so unfortunately, class action attorneys are motivated by what they're motivated for.
Leslie,
I know that NAR is, defending these lawsuits. We don't believe there's any basis for them. We agree with you.
So I just wanted to
Yeah.
pose a question from like a consumer perspective. I'm not an agent, but I have been obviously around the industry for a long time. I'm just thinking about my personal experience. What does a post MLS world look like? Would it be like shopping for furniture? You have to go to 27 stores to figure out what's available. How would that look?
Yeah, I mean, your guess is as good as mine, but it might take us back to the 1800s before the MLS existed, where it was very fragmented. And that was why brokers came together, decades ago and decided to share information with each other, because otherwise, right, you had to know where to find the information, and it was very fragmented, and it was decentralized. And so we certainly don't want to return to those days, and it would not be in consumers' best interest. And we're confident that the courts will eventually see it.
And I guess one of the things that I see is that there seems to be some sort of idea that the buyer should be paying their own commission. Has anybody explained to us where the buyers are supposed to get this money?
Well, I mean, that is an issue, right? Because the buyer's commission it's not going to be financed by the banks. And so that would lead them to being able to afford less of a home, right? Because they already have to come up with that down payment. How are they going to come up with tens of thousands of dollars more to pay the agent? Or they're not going to be able to buy a home, period, right? The home ownership's going to decline. So that's certainly part of what we'll be using to argue in these cases. And the fact of the matter is, these class action plaintiffs point to other countries where commissions are lower, but they don't have an MLS. We're the envy of other countries that don't have an MLS, where it is fragmented and difficult, and they're completely different systems.
Other countries do a lot of things different than America. I don't even think that argument will hunt. It just doesn't make any sense to me. Are we going to start being like other companies, or are we going to say capitalism is dead? What are we doing here? It just doesn't make sense to me.
Kim Clay has a question.
Yeah, I've got two questions. First, thank you, Leslie, I felt like I just set like a virtual arraignment. I feel like I'm in trouble. But is this a lot? Like, is NAR really is this a lot of lawsuits, or is this kind of standard, operating procedures for y'all? Or do y'all feel kind of under fire at this point?
It's a lot. I mean, this is definitely a wave of litigation. They're all related. They relate to the same rules. The DOJ settlement, these buyer class action lawsuits, but they're all related, and it just is what it is. But in my time at NAR in the last 10 years, I've not seen this many lawsuits. But we were investigating, back in 2008, there was a DOJ investigation. So like I said, in response to another question, the real estate industry is constantly under scrutiny, whether it's government entities, plaintiffs, because we are such a foundation of the economy, and there's a lot of concern about just preserving competition. So that's where this stems from, and we are very well equipped to handle these cases. Litigation firms helping drive our strategy and responses. So just know that we have experts handling our defense.
So back to the lockbox. I'm sorry, am I interrupting? I couldn't tell.
Can I do a second?
Has another question.
Just a follow up to that. On the education piece, I get a lot of wisdom from agents like Chip who were around when the buyer broker agreement or buyer brokerage, cooperating broker was created. But was DOJ involved in creating that, or is that all NAR deciding that a buyer actually needed representation as opposed to just like knocking on the door of the listing agent?
No, the DOJ was not involved in how that representation of the buyer developed. I mean, I know years ago, it was a sub-agent of the listing broker, and it changed to the buyer having a separate representation, which is part of the question in these various legal challenges, is why does the offer of compensation continue to exist when it changed from sub-agency to a distinct buyer representative in the transaction? So, I mean, that's kind of some of the questions that have been raised in these lawsuits.
In regards to the lockbox situation, will there be anything that prohibits a local realtor membership organization from charging higher fees to join the lockbox company if they're not a member of the association?
So, as I said, these rules are in draft stages, but one point that I made when I was talking about the lockbox access is that we envision that it will be permissible to charge a fee to these non-member licensees that are getting access, but that charge must be reasonable. And so charging them more than what other participants are charged could fall in that unreasonable category.
Leslie,
I
what
think,
a little bit
I think
of
she's really breaking up. I couldn't hear a lot of that.
Oh, you can't hear me?
There we go. Yeah.
Oh, sorry. You know what? I probably am sitting too far back from my microphone. Do you want me to repeat my answer?
Please. I only got about half of it.
Okay. Okay. So I was saying that when we discussed the lockbox access rule, first of all, they are draft rules. And we envision that a reasonable amount can be charged to these non-member licensees, but charging them more than what other participants are charged could fall in what is an unreasonable fee. But there'll be more on more direction, I think, and guidance on fees as we get closer to final rules.
And nothing that you can do, Leslie, but it really grinds my goat for lawsuits like this to think that buyers agents are not working hard for their dollars today. Buyers agents are probably working harder today than they ever have in this market to get their clients' offers through. And the premise that the buyers are paying too much for their house because they're paying these fees, do you think the sellers are just going to give that money back to the buyer for what they could have profited from the house? It's all silly.
Yeah, no, I'm absolutely with you. I just bought a home myself and I made my agent work. I made my agent work. So obviously we agree with you. Any other questions on that? Otherwise, I'll move on to Code of Ethics. Another exciting topic. Okay. All right. So I'm excited to talk to you about the new standard of practice 10-5 and its implications for you as realtors. So it's good to start this conversation at the beginning, which is the beginning of time for the Code of Ethics was adopted back in 1913. And so it's been around for a very long time. I guess over 100 years. And so as you all know, the Code of Ethics is premised on the Golden Rule as its foundation, which means moral integrity and competent service to clients and consumers. And realtors are charged in the Code of Ethics to uphold and adhere to that integrity for the industry and in the practice of real estate. And so because of that charge, the Code of Ethics has changed many times over the last 100+ years. And it's been changed to reflect that changing marketplace, to reflect the changing needs of consumers, and to reflect the different values and perceptions of societies. And so with that comes the standard of practice 10-5 that reflects those changing, the need to keep changing the Code of Ethics to make sure that it reflects that changing marketplace perceptions of society and consumers. And so at the November 2020 Board of Directors meeting, NAR's Board of Directors adopted standard practice 10-5. Sorry, I'm all over the place here. So 10-5 flows from the requirement not to deny equal professional services or to be parties to a plan to discriminate. And that applies to all consumers as well as your fellow realtors. And so in essence, 10-5, as you all likely know, bans hate speech in any context. Realtors are prohibited from using hate speech against any of the protected classes identified in the Code of Ethics in any context. So here's the actual standard practice 10-5 that was adopted and made effective November 13. 2020. And so it's helpful, I think, to reflect back on some words from our past president, President Lyndon Johnson, from the time when the Civil Rights Act of 1964 was adopted. And he said the purpose of this law is simple. It does not restrict the freedom of any American so long as he respects the rights of others. And that is directly applicable here. The Civil Rights Act gave equal rights to so many people in different contexts like transportation and employment. And the purpose was not to restrict the freedom of any other American. It was so that those Americans could not restrict the freedom of others. And so here is the same thing. And it's good to think about standard of practice 10-5 as it's not a mandate about your beliefs, but about your behavior and how you conduct yourselves, as opposed to any belief that you might hold. So, hold on, let me find my place. Sorry. The test and standard for whether or not standard of practice 10-5 has been violated is to look at the statement and the conduct and the context. And it's very hard to give any concrete example of what constitutes hate speech that would be a violation of standard of practice 10-5, because that privilege and right is really with the grievance committee and the hearing panels to determine in a particular context whether that statement is a violation of the standard of practice. But it's helpful to look at the dictionary definition of hate speech, which is speech that is intended to insult, offend, or intimidate a person because of some trait. And so here we're looking at whether or not that hate speech was directed at an individual of a protected class under the Code of Ethics. In addition to adopting 10-5, standard practice 10-5, the board also amended the applicability of the Code of Ethics to apply in all contexts, which caused a lot of concern and discussion when these changes were being debated and ultimately adopted. And so because standard practice 10-5 does apply to all contexts, all hate speech by realtors, this change was necessary. But when you look at the rest of the code, it really is limited to apply in the context of real estate transactions. So standard practice 10-5 is unique in that sense. The definition of public trust was also expanded in these changes to the Code of Ethics to include all discrimination against protected classes and all fraud. And so that first change related to discrimination was really an administrative change because there's no such thing as intentional discrimination. Discrimination is discrimination, it just is, whether it's intentional or unintentional. So that change was necessary. And then the second change was a substantive addition because before it only related to fraud just as to finances. But so now it applies to fraud generally. And so if there is a finding of fraud, it must be reported to the state licensing agencies. So specifically to standard of practice 10-5, and if there's a violation of standard of practice 10-5, if that violation is outside of the context of real estate, that would not be reported to the state agency. It's only things related to real estate. A lot of questions that we've received about this new standard of practice relate to its effectiveness. And so as with all Code of Ethics changes, they are prospective, not retrospective. So there's no concern that one of your fellow realtors is going to go combing through your past social media posts or find something you did or said 20 years ago or 10 years ago or even 3 years ago. Because the Code of Ethics standard practice 10-5 will not apply to those. It only applies to any conduct or hate speech towards a protected class that occurred from November 13, 2020 and thereafter. NAR has an incredible amount of resources about standard practice 10-5. There's a lot of education happening around standard practice 10-5. There's scheduled monthly videos. You can find all of the past videos that have been done on our website. As I said, monthly training sessions. So I really encourage you to go there, take a look at those resources to learn more about standard practice 10-5 and what it means to you all as realtors. And also, if you specifically look at the January video, it will walk through some examples and how potential hate speech will be evaluated by a grievance committee and hearing panel. So with that, I'll take any questions on this or anything else that I've talked about today.
Leslie, I'll jump in and ask a question that we had talked about just among the staff yesterday when we were preparing for this. Have you heard of any specific cases that have come up that have been violations of 10-5 since it went into effect?
That is a really good question. So I don't know. I don't know. I imagine there have been, but it's at the local association level that those hearings are taking place. So we would only hear about them if someone reported them, and I probably wouldn't be the one they're reporting it to. So I'm sorry, I don't have a specific example. I have heard of a complaint being filed that was dismissed based on that time implementation. So the complaining speech that took place occurred before November 13th of 2020. So that complaint was discharged.
So we had a question in the chat about would 10-5 apply to any realtor that was involved in the January 6th event at the Capitol?
So I think something that's important to know is that, and this might not be satisfying to you all, is that I can't say whether it would. I'm not the arbiter or decider. That really is the grievance committee and hearing panel. But just with that, in that context, you have to look at whether there was any hate speech. You know, you have to look at what were the statements. Near participation, I'm not sure that would fall within the context of the SOP 10-5. And was it directed at a protected class? Just from that example, again, I also don't see how that is directed towards a member of a protected class. But as I said, it would really have to be evaluated at the grievance committee level.
All right, thank you. So Lynn just said in the chat, it's not about your beliefs, about your conduct. But then there was a statement about whether the speech was intended. As a board member and a professional standards committee member, how do we determine intended? Intent obviously makes a difference in this situation.
Yeah, I mean, I think you have to look at the context. You will always be looking at the context of the speech and how it was made and what the statement was referencing. I can't give you a concrete example to say that there's no like approved list of hate speech or unapproved list of hate speech. It's all about the context in which you say it. I've received questions about like religious beliefs, like if you say something from the Bible that might offend somebody that's in a protected class. But do you want to look at the context in which you are using it, you're saying it? Like, for example, are you a preacher talking about religious beliefs in a church? Or are you saying it specifically directed towards a member of that protected class and using that religious belief to insult or intimidate or disrespect a member of a protected class? So it really is about the context in which the speech was made.
Okay. I know I can't see many of you right now, but any questions? And I know that there's been a lot of slides and Leslie has sent those to me. So I will do a follow-up to everyone who registered and send those slides out so that you've got some of those resources and can check out these websites. Anybody else? Any last lingering questions for Leslie?
I would just ask Leslie if she has any really good news to share with us today.
Oh, that's a great note to end on. Good news, Leslie.
Oh my gosh.
We're really putting you on the spot.
I should think of something.
Well,
It's gonna be the 60s where I live. I don't know.
You can't leave us like this.
Leslie's in Chicago. I'll say from the realtor perspective, I saw a statistic that said 25% of the Virginia population has been vaccinated against COVID-19. So I think that is an enormous.
Yeah, Kim shared the good news at the beginning, which was that you all are now eligible to get the vaccine, which is amazing news.
Yes. So just a real quick one before we leave. Could we please revisit reporting of ethics violations to the state licensing authority? So that was that issue of fraud.
Mm-hmm. Right. So all instances of fraud will be reported to the real estate licensing body, but specifically with respect to 10-5 and hate speech occurring outside the real estate transaction context, that would not be reported, but all fraud would be reported to the state licensing body.
Okay. All right. Well, thank you.
Well, if I could add one thing, Leslie, will there be any follow-up for members? I mean, we belong to this membership with 1 million members.
Mhm.
Are there going to be pieces that are going to be sending out to the membership, letting us know what you're doing to respond to these lawsuits?
Absolutely. So there's lots of information on our website, which I've shared some links. If you are a member of the hub, Katie Johnson, the General Counsel and Chief Member Experience Officer, is posting updates about the lawsuits on the general forum on the hub. And if there aren't any updates, it's because, or posts about the lawsuits, it's because nothing's happening. Like for instance, in Merle and Sitzer, those class actions related to home sellers, we've been in the discovery phase for quite a long time and nothing has happened since our motions to dismiss were denied. But you can go to the hub to answer your question, Chip. You can go to the hub general forum for updates. You can please visit the NAR.Realtor webpage dedicated to the DOJ action and settlement, because updates are being shared there as well. And go to our website. Just generally, we have a lot of information on the antitrust lawsuits that I shared some links for.
Thank you very
Those
much.
of you who are like, oh my gosh, what is the hub? I don't know what that is. I'm not on it. We share everything that comes out from Katie. And like Leslie said, there's just not been a ton of stuff. So if you haven't seen anything, it's not that you missed it. If you do want to go back and take a look at what we have posted, we always do it connected as a blog post that you can go to the news section on the FAAR website and then filter by policy and advocacy. There'll be all of I just reproduce exactly what I read in the hub. We link it on social media. It's usually in the Friday update. So when there is information to be shared, you can be sure that we'll make sure we draw your attention to it.
Yeah, and be sure that if and when we win these lawsuits, that information will be disseminated far and wide. But these class action lawsuits can go on for years, unfortunately. And it already has been years, and it could be many more before we see resolution.
Well, Leslie, thank you. This has been really, really great information. This is what I love about Zoom. We can beam Leslie in from Chicago and get her to get to hear it straight from our legal counsel, folks that are working incredibly hard for you every day to defend the business that is your profession. So thank you. I'm happy to hear you're having a 60-degree. We are having a 70-degree day.
Oh, always better in Virginia.
So folks can get outside and enjoy, not a sunny day, but a warm day. So thank you to Carrie for her great leadership and to all the great questions that were asked, and for you all for making this a priority and being here today. So thank you.
Thank you all. Have a wonderful day. And feel free to contact me if I can be of any help or answer any more questions about these topics or anything NAR.
Wonderful. Thank you, everybody.
Bye-bye.
Bye.
Bye.